Perfect, and welcome everybody. Without further ado, I'm going to now turn this over to Craig, Craig Sherburne. Craig, thank you so much for your time today, and yeah, please take it away.
Sounds good. Thank you. Thank you, everybody, for attending. This is an excellent turnout. I will apologize because my monitor is wide and big and my camera is small. So I assure you I'm not watching a football game off in the corner. I'm checking chat and or checking to see where my talk is going. Sometimes my talks will surprise me as much as it surprises my audience about where we turn our attention to. Nonetheless, I am going to share my screen. Oh, look at that. That would work much better now, wouldn't it? Give me 1 second. I'm just going to make sure that my chat comes up here. You know what? Chat has disappeared on me. Dale, would you mind watching the chat? If there are any questions, just interrupt me and I'll take advantage of that there. Or alternatively, I will have lots of time for questions at the end. There usually is a plethora of questions, and I'm just full of answers.
Perfect.
I got lots of letters after my name. I've worked in many different areas in law. I was a patent attorney and still am a patent attorney in the US and Canada. I do a lot of patent law, but I also had worked in securities and for public companies, and I was in venture capital and investment banking for a number of years. And so I've kind of settled on being the lawyer that is what I refer to as a corporate commercial lawyer. So if you have a company, if you have a business, I want to be the guy that if I don't have the answer immediately, then we'll have it in just a short time. So general know-it-all doesn't flow well on a business card. So instead, I'm kind of going with corporate commercial entrepreneurial lawyer. Okay. As a lawyer, I get a lot of questions. And so I want to start this off by saying, here, look, let's answer the top 5 entrepreneur questions. It's going to lead to the title of this talk. So spoiler alert, there's a reason why I'm doing this. But here are the top 5 questions I get from entrepreneurs all the time. Number 5 is, when do I get to sell? And although this could be a complex question with a complex answer, it's actually quite simple. You will get to sell when somebody wants to buy. There you go, for a piece of cake. Number 4 is, how much do I get when I sell? And again, very complex, but after years of experience, I can tell you it's going to be the highest they're willing to pay and the least you're willing to take. There you go. That's, boy, that's 4 right off the bat. Number 3, how much of my business do I have to give up to my investors? Again, a very complex question with a very complex answer, and that's going to be the least that you will take and the most they will give. Oh, no, the least they will take and the most you will give. Look, that's how complex it is. Number 2, what terms do I have to offer to my investors and financiers? Now we're getting into the meat of it. Taking investment, receiving capital injections into your company can be a very complex process, a lot of give and take. How do you know what terms you're going to need to give to your investors? And the answer to that is, don't worry, they will tell you. They have the money. They're only going to give you the money when you have something, or when they're only going to give it to you when they want to. And so they will tell you what they want to see before they give it to you. Don't you worry about that. And then finally, the final question is that I get asked, and the number 1 question I get asked all the time is, do I need to incorporate? And that's what we're here about here today. People think that companies are the end all and be all to success as a business. They do have their strengths, they do have their weaknesses, and we're going to tell you those strengths and weaknesses here today and let you come to your own conclusions. Now, I like to start with stories. I'm a narrative storyteller by nature, and I think that stories can contain so much more information than just data or PowerPoint, so I'm going to tell you a story. I'm going to tell you a story about Archibald Reginald Wilkins III, who goes by Archie. Now, Archie has a brilliant business idea. He is going to entertain he's going to entertain the concept of going into the space of door-to-door sales. Because door-to-door sales is really fallen by the wayside with the new internet age. So he's going to go into door-to-door sales, and he's going to sell 2 products. Those products, as he's sat down and taken a look at the market analysis, first he is going to sell a lemon lime flavored soda. because who doesn't like a refreshing lemon lime flavored soda? But he also feels that there's a gap in the market, and that is for lemon lime flavored laxatives. And so he's going to sell only two products, right? Lemon lime flavored soda, lemon lime flavored laxatives. Well, where is his competitive advantage going to come from? And he's going to do it by cost savings, because Archie has come down to the conclusion that he is going to save costs by having the same kind of can and the same kind of label for his laxatives and his sodas. But he was not raised a fool. I mean, that would be incredibly dangerous and stupid to be randomly selling soda and or laxatives. So he has come up with the measure that he is going to put a sticker that says this one's a laxative on his laxative cans. So what could go wrong here, right? So he goes and he incorporates Bob's Sales Incorporated, because he's watched YouTube videos, he's talked to people on the street or on the bus who say you really need to incorporate. And he does this for a couple of reasons. The first is that Archie wants to all the profits that he's going to generate from this brilliant business model. He wants them to be taxed separately from from his income for his day job. So he wants to incorporate so he gets separate taxes. The second is that, you know, he's worried that he might just get sued. And so if you incorporate, according to YouTube and the people he met on the street and on the bus, if you incorporate, then you're not going to be sued, you're going to be safe. The third reason is he's afraid that he might get doxxed. So that's why he's going to call it Bob Sales, so that nobody knows that Archibald Reginald Wilkins III is selling soda and laxatives. But he's really worried that he's going to be doxxed by, of course, the pro-constipation activists, which are out there, and they're going to hate everything that he does. So Archie decides that he's going to pop on down to the registry's office. He's going to turn over $400. He's going to get 5 pieces of paper, and Bob Sales Incorporated exists. He's happy, he's comfortable, and he goes off and he starts selling, you know, comforted by the knowledge that he is safely shielded behind his corporation. What could go wrong? Well, there is an opportunity that Archie takes where he is going to participate in a wedding proposal balloon ride. And he's going to cater the event. So he's going to be in the balloon. He's going to go up there and cater the entire event. Archie hands them. Oh, that's a. Who do we have? Dale, do you have the ability to mute there?
Already done. Sorry.
Excellent. You're on it. Sorry. Perfect. So Archie is up there catering the event. He decides to hand the two parties a celebratory soda. Now again, he checks. There's this one's a laxative sticker on it, so he knows it's a soda. He hands it to them, and then he finds 2 stickers laying on the bottom of the cooler. And he suddenly goes into a cold sweat as a celebratory soda at 1,500 feet goes very wrong for the couple. Now the question is, did incorporating help Archie? Now, all of that is going to be answered in a little bit. But before we actually answer that, I want to answer the question of what is a company? What is a company? Well, a company is legally a person. It can hold property, it can enter into contracts, it can conduct business, it can pay taxes. Now, that's to be distinguished, though, from an individual. So an individual, which are human beings, you and I, versus companies, which are legal capital P persons. Well, individuals can hold property, and individuals can enter into contracts, and individuals can conduct business, and individuals can pay taxes. So you would say, well, companies and individuals seem to be the same thing. Well, they're not, because an individual can do a few more things. An individual can die, and that's really relevant and important. Individuals die, corporations cannot. But that might seem to be a real downside of being a human being and an individual, but there's some upsides. Individuals can give gifts. Corporations can't give gifts. I, as an individual, can gift all my money to a scammer who called me at 3 o'clock in the morning to tell me that my Amazon account has been hacked. That's my choice. Individuals can throw baseballs. They can throw footballs. They can do lots of things. This here is touching on the fact that individuals have a physical, corporeal existence where corporations do not. See, corporations have no arms, They have no minds, they have no pockets. They are 5 pieces of paper that we choose to recognize as having personhood under the law, because it actually allows businesses to conduct in a smoother manner. Uh, but since corporations are 5 pieces of paper and they can't throw baseballs, and corporations can't themselves pay taxes, they need somebody to actually push the button electronically to communicate that money over to the government. They need to have individuals doing things. And those individuals are called the directors. So the directors are the brains of the corporation. They provide, as the brains, the big picture direction on the day-to-day operations of the company. So the directors of the company are the brains. Now, if you have nothing else in a company, they are also the hands and arms and legs and brains of the corporation. But by that, we actually have to distinguish and separate out. Directors are the brains, but companies need what are called agents. They need corporeal human beings to be doing things on behalf of the company. Now, those agents can be officers. We know of an officer. I'm an officer of the company. They are the day-to-day operators. They have titles that we recognize: president, chief operating officer, vice president, executive in charge of corporate finance. I had the officer title for one client once as corporate ninja. And yes, they did get a discount on my hourly rate because they gave me such a cool title. So it worked. Flattery will get them everywhere. You can have officers as agents of the company. You can also have contractors. Those can be lawyers, your accountants, graphic designers, bookkeepers. Contractors, their powers are limited by contract. So there is a contract between the company, thus providing the title of contractors. Finally, you can have agents that are employees. Their powers are limited by the contract as well, and we all know what an employment agreement looks like, because hopefully we've all had one, and if we haven't, then someday in the future you'll all be lucky to be employees of somebody. So those are your agents. Those are the people that can do things on behalf of the corporation, distinguished from the directors that are the brains. Now, the law has to start somewhere, and they start with the position that all right, power, title, and authority to operate on behalf of a company starts with the directors. They have all the powers. And there's a waterfall concept that I like to repeat, which is the power of a corporation flows like water from a waterfall. The top of the waterfall is the directors. The directors, if they do not delegate anything to the officers, then all power starts with the directors. They have to be the hands and the arms of the company, because they haven't delegated any authority to an agent in the form of an officer or a contractor or an employee. So it all stays with them. But if they do delegate, they can delegate power to the officers, and the officers may further delegate that down to other agents, other officers, or other employees, or other agents. But the key thing here is everything starts with the directors, okay? So all the power starts with the directors, but a company has 2 components. A company has directors, and then it has, surprise, surprise, shareholders. And I started with the directors because in Alberta, you don't have to have a shareholder. You should have a shareholder, but you don't have to. You cannot incorporate a company without a director, but you must incorporate a company without a shareholder. And at some time for the future, the directors will give some shares to the shareholders, but the directors hold all that starting power. If a corporation does have a shareholder, understand it is entirely a passive role as a shareholder. You have limited liabilities to the corporation as a shareholder, and there are limited liabilities for the actions of the corporation on behalf of the shareholders. If the corporation goes off and does something wrong, there are very, very few circumstances where the shareholders would be held liable for the actions of the corporation. This is the thing that Archie was told about on the bus, that there are no liabilities for shareholders for the actions or liabilities of the company. That's what he relied upon. There are, though, as a lawyer, a few rare exceptions, okay? And those tend to be created by statute, and environmental protection laws are the number one that comes to mind. There were a number of shareholders that were standing behind the corporate wall or the corporate veil, saying we as a shareholder shouldn't be responsible for all the oil cleanup mess that the corporation went and did. And so there was a few limited circumstances where the government will say, you know what, we're going to hold the shareholders liable, but they're really limited. Okay. So what's the good of having a share? It's a passive role. Shareholders only get to do up to 3 different things. Now they have to do one of the things. A shareholder must have the right to one of them, but it doesn't have to have the right to all 3 of these. So the first thing a shareholder gets to do is that they might be able to vote at a meeting of the shareholders. Usually that's once per year. Not very exciting as a shareholder so far. I don't know what I would do with a vote that counted, and the idea of voting at a corporate meeting tends not to excite people. But there's a second thing that shareholders can do, and that is they can participate in the profits of the company. Now that's much more interesting. That's what people are usually interested in with shares. Is as the company has profits, they're going to receive some of those profits as by virtue of their holding shares. We call those dividends. If you receive profits that are spun out from the company to its shareholders, that's via a dividend. The third thing is they get to receive the assets of the company on winding up. Now that's up to 3 things that a shareholder can do. A share, if you have a share, you must have one of them. You might have up to 3 of them. You cannot have 0 of them. If you have 0 of them, then it's not a share, and there's a problem from a legal standpoint about what they've given you. They've given you a piece of paper, and that's not exactly what you were looking for. So now we know what shareholders do. Shareholders are passive. They get to do up to one of these 3 things. Usually the reason you have a share is because you want to participate in the profits, and you want access to those greasy profits that are all going to come from the company you hold shares in. Directors hold all the power. Directors can devolve that power down like a waterfall to officers or people they appoint beneath them. But it all starts with the directors. So now let's go back to what Bob was doing. We know what a company is. We know what directors are. We know what shareholders are. We know Bob. So let's go back and revisit Bob. Archie, under Bob's sales, he has his company that sells 2 products, a lemon lime flavored laxative and a lemon lime flavored soda. So he's up there in his wedding proposal balloon ride. He hands both of the people 2 what he thinks are lemon lime flavored sodas because they don't have a sticker that says it's a laxative on it. And it goes tragically wrong and they sue. So now Bob's thinking to himself, did incorporating help? And I keep calling him Bob because he didn't want to get doxxed there. But so Archie says, I can't get sued. I'm fine because I'm a shareholder, and shareholders are not liable for the debts, liabilities, or actions of the company. So he rests assured, and he looks him in the eye and goes, the best you can do is to get whatever money the company has, which isn't much because I was wrong about how excited people are about lemon lime flavored soda and lemon lime flavored laxative. And maybe you can get my stock in inventory. So he goes home and he sits down and he says, I'm saved. And then he decides to ask a lawyer, hey, I'm okay, aren't I? And the answer is summarized as nope, you are not. Because Archie is protected as a shareholder. Right? Shareholders have limited liabilities on behalf of the actions of the company. There are some exceptions, but environmental protection laws don't extend into laxative accidents in balloons. We're safe there. But the problem is he was also the sole director, officer, and agent of the company. So Archie is not liable as a shareholder, but he is liable as the director of a company that thought it was a good idea to sell laxatives and sodas in the same can with the same label and only differentiate by putting a sticker on it. And on top of that, he's also liable as the officer of the company who was carelessly supervising the application of the It's a Laxative label at the warehouse. And finally, he's also liable as the agent who negligently passed the cans of laxative to the newly engaged couple at 1,500 feet in a balloon. So we're not so sure that incorporating saved Archie. And we're definitely not so sure that all the costs that he incurred in creating the company did what he was hoping it would do. Now, there are some advantages to creating a company. I am a lawyer. I will push and pull at the same time. I'm fine with that. So I'm willing to say and happy to say and encourage with many people, there are some really good advantages for a company. One of those advantages is isolating the liabilities from the shareholders. But that only really works if the shareholder is not the sole director or is not also a director and is not also an officer and is not also an agent. If you are purely a shareholder, you're fine. If you're doing things on behalf of the company, then it's possible that you might do something that makes you liable as well. We have a question from Yasser. What the heck? Let's pause it. Yasser, yes. Let's see if I can find the chat. Floating around.
Yasser has not put his question in the chat.
Okay. Well, I'm going to ignore it then. Maybe Yasser's playing with some buttons. Throw it in the chat, though, Yasser. Okay. So there are some advantages of a corporation. One is isolating the liabilities from the shareholders. There's also the advantage that it is an independent person. It is separate and distinct from Archibald. Bob Sales was a separate and distinct separate and distinct legal entity from Archie as the individual. It can hold property. It pays taxes separately from its shareholders. It can have multiple shareholders, right? Why is that good? Well, that way you can easily have a method for sharing profit from the business enterprise that's being operated by the company. You can share in the assets on winding up, because that's one of the things that happens with holding shares. So there's some real advantages to a corporation. And hey, it's so easy to create one, and you get all these benefits. Why don't we just go and create a company, is what a lot of people will say. Yeah, it's really easy to do it wrong. Right? Most people think that creation of a company is a simple 3-step process. Step 1, you go to the registry office. Step 2, you start issuing shares to anybody who makes eye contact. And of course, step 3 is the common one: profit. Right, there you go. There's your 3 steps to success. You go to the registry office, pay your $400, start selling shares, and profit. That's not the case. That is not the case. And so what I'm going to do is I'm going to run through the really avoidable problems that people don't avoid, and you should be doing so. Okay, it breaks down into these 5 categories. The first being the legal requirements. I say this as often as I wake up every day. So 3 times a day I say this. 4 pieces of paper from a registry office does not make a corporation. You, by law, can't just wave around the 4 pieces of paper. You, by law, have to have organizational minutes or a resolution of the shareholders and the directors. They need to get together. They need to turn their mind to some key questions in those organizational resolutions. The directors have to say, where is our office going to be at? What is our year end going to be? Who is going to be our agent for service? That is the person that actually legally can receive documents and be considered to have accepted those documents as service of the corporation. Shareholders have to get together and say, who is the director going to be? It's necessary. You have to have annual and director and annual shareholder resolutions or meetings of those people in lieu of the resolutions. You need to file annual returns. You need to actually issue share certificates. There is an electronic equivalent of it that I see floating around, which might be acceptable, but it's still a share certificate, electronic or on a piece of paper. You need to have these. By law, you have to maintain a register of the directors and the shareholders of the company. That register needs to be at the records address, which begs the question, you need to have a records address. You need to have a registered address. You can't just have these 5 pieces of paper that the registry office handles you. So the registered address, that's where the corporation can be served documents. I see a lot of people who say, well, I only have one address, and that's my house. So I'll put that as the registered address. Well, that means that the service of the company, if you're going to get sued, happens at your home. If you are served documents in a lawsuit, there's a timeline to respond. The Court of Justice, it's 20 days. So if you decide to create a company, you decide to use your home as the registered address, then somebody can serve the corporation by simply leaving the documents at your home. If you are on a 3-week vacation and you come home and find that somebody had served you 22 days before, then you have not responded in the 20 days that you've been given, in which case you can be found in default of judgment. That you lost a court case that you didn't even know you were in because somebody went and served it to your house and you were on an extended vacation. So using your home address, aside from just the public nature of that document, of the public nature of the corporation's registered address, you actually could be served just by them dropping it off at your apartment door. That could be a problem. The records address is where all the information by law you have to keep is supposed to be at. And people can show up at your records address and demand by law to see corporate information. Now, not all the company's information, just select things. For example, the register of the directors, they get to see the shareholder register. Well, now you've got people knocking on your door, asking to see things that you have no right to withhold from them. So just be aware, the registry office, your records office, if you're using your home, there are consequences and side effects. Can they sue you through Canada Post? Yes, there is a process where sending a letter by registered mail to the records or registered office, sending a document by registered mail to the registered office of the corporation can be good and sufficient service. In which case you're not picking it up because usually Canada Post will only hand deliver those documents. You're not picking it up becomes a problem for them because they have proof that you didn't get it. They just tried to send it. So usually what they'll do is instead of that, they will send a process server or just to the registered office and then just drop it off. It saves a step. So the registered mail doesn't save people from being served that way, I'm afraid. Okay, next, Securities Act. You just can't. You can't sell shares. That's our securities law in a nutshell. The legalese of this is no security may be traded absent reliance on an exemption to the prospectus requirements and by otherwise complying with all applicable laws and regulations. I'm going to summarize that into practical English. You can't sell a share unless a professional tells you to. That's it. The Securities Act is a convoluted piece of legislation that starts with the proposition you cannot sell or exchange a share between individuals or persons in Canada, period. Now, the next part says, except if you do the following. So there's tons of exceptions, and then there's exceptions to the exceptions. In general, you just can't do it without talking to a professional. And if you do it without talking to a professional and you do it wrong, then you can be liable to substantial penalties, including jail time. So if you want to sell a share, trust me, there's plenty of ways to do it legally. The problem is it's probably not as many as you want. You can sell to friends and family and wealthy individuals piece of cake. That you can trade shares and you can give shares and you can sell shares from your company to these people to raise money for your company, no problem. But there are some reporting obligations, though. I mean, this is where it gets risky. If you're not talking to a professional, then you might not be reporting the exchange and the issue of shares, and the consequences can be severe. Fines, lawsuits, jail is not unheard of. They tend to save jail for the really bad actors who have been making millions of dollars, but as a lawyer, I have to say it's a risk that's out there. Another problem that people run into is taxes on corporations. So corporations are taxed as independent persons. So you do need to file tax returns on behalf of your corporation. If you do not, the CRA will come and start demanding these things from you. So if you're filing separate tax returns on the company, there's additional costs. You might have to, whether that cost is going to be time or having to buy another subscription to QuickTax or hiring an accountant, it's still there. There are some positives. It opens up some additional opportunities for deductions, and tax deductions are a great thing. But there's some downsides. So one of the downsides is when you're profitable, or I'm sorry, one of the upsides is when you're profitable, that's great because all that profit, the taxes are coming from the corporation and not from you. and taxes for corporations are much lower than personal taxes. It's one of the great things. The problem is when it's losing money. Oh, surprise, surprise, that's bad. And it's bad because the losses of the corporation that you might very well be the sole shareholder for, and you might very well be paying and writing checks into the company, those to be able to maintain its operations. Those losses are coming out of your pocket, but those losses are trapped in the corporation. You can't claim those losses against your day job's income. You have to, they're trapped in there, and there's realistically no way to get them out. So it was the best of times, it was the worst of times. It's the best of times when you're making money, because if you were making those profits as an individual, you'd be paying 42% tax. But you're making them as a corporation, so you're paying 19% tax in Alberta. That's great until you start losing money and you realize, well, what do I do now? Finally, I believe finally, shareholders. Look, shareholders are a great idea. And that's usually where it stops, is a great idea. You have shareholders because you want to raise capital, you want to share the profits, you need money in the company. There's only three ways to get money into a corporation. You need to sell wares or services, you need to borrow it, or you need to sell shares in the company and raise capital that way. So you decide to sell some shares to the first person that company or that you see, which will most likely be friends and family. Friends and family are usually your first shareholders, and it seems like a great idea, except if you thought that Thanksgiving was uncomfortable because of Uncle Doug and his Make America Great Again hats. Wait till he looks you in the eye and goes, I pay your salary. Very uncomfortable family reunions, as they are now saying, hey, where's my money? I thought I should have my money back by now. You told me that I was going to make 3 times my money in 3 weeks when I bought your shares, and it's been 3 months, which says get everything on paper, put it in writing. Don't leave anything to be remembered, or excuse me, more importantly, misremembered. Get the terms of the investment, get the expectations of the return, explain that it's high risk, and it's not just you doing the right thing. By law, you must follow a very explicit risk acknowledgement form if you are issuing shares to certain people under certain securities exemptions. Again, go back to the previous slides. Talk to a professional before you start issuing shares. Do a shareholders agreement. Get a contract in place between the company and all the shareholders. That sets up the expectations of the shareholders, what the company can do with or without the shareholders' approval, what the directors can do. And the really nice thing is, that the breakup language, getting that in writing, and dealing ahead of time. What happens when one of us dies is a question that is oftentimes answered in shareholders agreement. But the really important one is what happens if one of us doesn't want to work with the other one again. Get it in a shareholders agreement. Go to a professional. Get a document done before you start asking about how the breakup is going to go. One of the next issue is company property. So many entrepreneurs, I'm going to say most entrepreneurs, are not familiar with the difference between a company owning property and them owning property. They're not familiar with how to fill in a contract or an application form, or the one that's really tricky is credit applications. So I have oftentimes had companies come to me. No, I'm going to give you a story instead. So I have a company that had something like 200 employees. It was generating between $60 to $300 million a year in revenue. Nowhere near that in profit, but it was making really good revenues, had lots of employees. And the accountant came to me and said, we just got this credit application from the company that delivers us water. And so I looked at it, and at the bottom, it said, the undersigned agrees to be responsible for all charges associated with the sale of water to this company. And they said, that seemed a little weird. And I said, yes, they're asking the company not only to pay for the bottled water, but you as a level 3 bookkeeping entry administrative professional to also be responsible for the water purchases of the company. These are tricky things. When you go and do credit applications, when you go and actually enter into supply agreements, you will have the other side actively trying to make not only the company responsible for the debt, but you responsible for the debt. And if you created the company to be able to isolate the liabilities of the company from the shareholders, and you've gone through the effort to make sure that you've got the right directors and officers that are in place, the last thing you want to do is to have all those liabilities flow through because you weren't familiar with what the credit application you were signing said. Brand ownership. Company is created, you go off, you build a brand in Bob's Sales Inc. for lemon lime soda. It starts to be recognized. The brand starts to have value because people know when for a great laxative, they go to Bob's Sales. Who owns the brand? Have you executed the paperwork to clearly and definitely transfer the ownership of that brand to the company? Who owns the ideas that you have? Have you written the paperwork to be able to make sure that your company owns the ideas, the concepts that you or your employees have? These are things people don't think about when they're thinking about company property because they're too busy off creating a business. They're too busy going off and trying to make income to hope that they might eke out a profit. I said that wrong. They're too busy going off looking for revenue, hoping that they might eke out an income. There we go. That's the my MBA training came back to me a little late there. Trade secrets. Who owns the secrets? Is it the company's secret? Is it yours? If you're going to try to sell your company, and I give another talk about how to get your company ready for sale. Well, if you're going to sell your company, you better make sure that all these things are owned by the company, that the person who's buying the corporation or the business from you is getting all of these things. And the way to do it is to make sure that the company owns it. Inventory. This might seem crazy, but this is a real sticking point. Storage location for inventory, protecting your assets from seizure. So if you have a corporation, you have a business, you have a corporation, but you have a roommate, or you are the roommate of somebody. So you are in their house, you're renting a room in the house, and you're keeping all your inventory in that house. And that individual suddenly gets everything they own seized. Well, they own the house, and the people who are seizing the house are going to assume that everything inside the house is owned by the homeowner. Now you have to prove that those assets were not the homeowners, they were actually the company's. Or if you're storing them at a warehouse, the same problem will arrive. What if the warehouse owner goes bankrupt? People are going to go in, seize all the assets in the warehouse, and now you're struggling to prove that the warehouse owner didn't own all your stock. It was you. Not going to be a problem if you're selling through Amazon, but it is going to be a problem if you are trying to sell outside and you have a place for your stock. Make sure you do the paperwork to show that who owns what, where the inventory is, and protect it that way. Okay, wrapping up here, lessons to take away. Look, there's no easy answer of whether you should incorporate it. It's going to be a case-by-case basis. One size does not fit all. But if you are going to incorporate, don't go to a registry office and get a piece of paper. That's not enough. There's the extra step to do. You don't have to come to a lawyer. You can go to, for example, accountants will help you with your incorporation. There are make your own minute books. Many registry offices will have a turnstile with a do your own legal will kit or minute books in a binder or some cute phrase. Those are not bad places to start. They're actually generally pretty good. Spend the extra money, pull the documents, read them, fill them in, put them into a binder, follow them accordingly. Of course, I'm always worried about the lawyers starving to death, so you should always strongly consider going to a law office because we do have to worry about those lawyers begging on the street corners. But you don't have to go there. There are other alternatives, but don't just simply go to a registry office and grab the documents, grab those pieces of paper from them. It can provide asset protection for you if you're set up correctly. If you're not set up correctly, then you spent a lot of money on creating a company, you spent a lot of money on preparing tax returns, and it all fell apart when the poop hit the fan, or in this case, the poop hit the bottom of the balloon basket. But one way or the other, make sure you do the paperwork to get the assets into the company. If you want to have a corporation, you want to protect your assets through the corporation, then make sure that you have the right assets in the company and you have the documents to prove that they're there. Finally, and this might be the most important thing for people to take away, use different labels and cans for soda and laxative. It's, you know, you might be saving money, but it's probably not worth it. It's much better for you to actually distinguish them by more than a sticker that says it's a laxative. Okay, this is me and the collection that I've gathered over the years. I am going to now pop over. Were there any questions in the chat, Dale? Or if there's any questions now, there should be a little hand raising.
Yeah, absolutely. So Ash had a good one earlier in the presentation. He wants to know if the share type, and he's referring specifically to common and preferred shares, changes things from a liability perspective. And maybe for everybody else, what's the difference between common and preferred shares?
Absolutely. So we talked about the three things that shares have to have: the right to vote, the right to participate in the profits of the company, and the right to receive the assets on wind up. Preferred means that they get their bit of one of those last two things first. They have a preference over the profits that are going to be distributed, or they have a preference over receiving the assets on wind up. So that's all a preferred share means. Preferred shares can oftentimes look like loans, is because when you say, I am getting this share is going to be worth $1,000 per share, and I'm going to have 10 shares, and I get my money back from the company first, either through the assets on wind up or through a dividend. It sure looks a little bit like a secured loan at that point. You're getting your money back. The share can be redeemed, which means the share can be exchanged for cash by the company. And then oftentimes there'll be this minimum dividend, which looks a lot like an interest on it. So preferred shares can look a lot like loans, and they do not change the liability whatsoever, whether it's a preferred share or a common share. It just means that they get paid first. The liability really comes down to what the shareholder, whether it's being the shareholder that owns a common share or a preferred share, is doing on behalf of the company.
Okay, perfect. A couple slides ago, you mentioned trade secrets. Was that a reference to intellectual property like trademarks?
No, trade secrets are intellectual property, but not to trademarks. So trade secrets are a form of intellectual property. They're only loosely recognized in Canada. Indirectly, I'm going to say recognized in Canada. There are some states in the US that recognize trade secrets as a form of property. But in Canada, and for the purposes here, I would say that a trade secret is stuff that is of value to you that you don't want anybody else to know. Most times for a business, it's going to be something that provides you a competitive advantage, where to find the best inventory that you use, or the means that you use to close sales. There's something special that you do. Hypnotism, for example, that allows you to close sales better than anybody else. Well, that would provide you a competitive advantage, and that advantage would be lost if people knew how you did it. So that's really what I'm talking about in the trade secret side. When it comes down to most businesses, transfer of trade secrets to the company means you writing down what that thing is and communicating that to the company in some way that the company can then benefit from. There's a phrase I use that the only difference between a hobby that makes money and a business is policies, procedures, and controls. Many people have very large operations that have been very profitable for a long period of time, but they are hobbies that make money because all of their policies, all of their procedures, and all of their controls are in the head of one individual who runs that business. Or runs that operation, I should say. If he isn't writing it down, if you don't have a book that describes exactly how to continue to make money at the same rate that you were making the day before your leader gets hit by a bus, then you're a hobby that makes money. You should be writing it down, getting it on paper. This is the way we do sales. This is the way we recruit customers. This is the way we deliver products. That book gets written down, or that book of those pages that describe that thing has now converted you into a business. More importantly, you have the ability to sell and transfer that business to somebody else by saying, not only do you get to buy my brand, not only do you get to buy my customers and my current relationships, but you get this book that tells you how to continue doing what we've been doing that you want to buy for the next infinite number of years. That book would contain a large number of trade secrets, and you want to make sure that you've got it clearly owned by the corporation, that the things that are on that paper are owned by the company. No such thing as a short answer from Craig.
It's all good. We've got the time for it too, so we're good. Jeanette would like to know, do you recommend incorporating when signing a lease on a commercial space?
Yes, because for a couple of reasons. The first is that your leases on commercial spaces are going to usually be very long. Leases will be for anywhere between 1 to 5 years on commercial spaces. That's a long obligation to pay money. So if you can incorporate and be able to isolate that liability in with the corporation on the company, all the better. The challenge here is that most landlords are too smart for it. Landlords will not allow you to sign a lease just with the corporation. They're going to want an individual guarantee from yourself and any other shareholders or directors. So you go through that effort to incorporate, show up with a commercial landlord, and he says, "No, joke's on you. I'm not giving you the lease unless you are all individually liable for the obligations under this lease." So do I recommend it? Yes. Does it work? Rarely. Rarely, because landlords are too smart. And I now see where my chat window was hiding, so I'd be more than happy to answer to go through your, my apologies. Trade secrets, retooling costs. Trade secret could a secret recipe. Absolutely a secret recipe. You're right. That's a great example of something that if it's not written on paper and you get hit by a bus and that recipe is lost, then where do your business is lost as well. Would it be better to start as a sole proprietor? What are the advantages or disadvantages? It depends strongly on the type of business you've got. In my example, it was quite easy. Archibald started a business where he was the chief cook and bottle washer. He did everything, which means that, and on top of that, the liability that arose, the wrong that was going to be acted upon through the lawsuit was a wrong where there had to be something actively done to give rise to the claim. He was the one that handed them the laxative instead of a soda. So in those cases where there's an active wrong, creating the corporation does nothing for you to hide you from the liability. But it did create a number of tax advantages or possibility for brand to be built up and placed into the corporation. It gave him the advantage that if he wanted to raise money, if he wanted to go and get capital, then he had the whole Business Corporations Act to assist him on describing to individuals on how they would participate in the profits of the corporation, how they would benefit from the investment that they gave into the business. If you take a moment, you think about how many words would it take to describe to your neighbor how if he gave you $1,000, you would give him a piece of the business that you are going to start, but you don't incorporate. Well, does he get a piece of the profits? Yes. Does he get a piece of the inventory? Oh, I guess I got to write that down. Does he get a piece of the tax savings? Well, no, only if we do a partnership, and we don't want to do that. So you start writing down all of the things that are necessary to be able to give a share of your business that you're operating as a sole proprietor to another in exchange for money. And you realize it's way easier just to give them a share, because everything that all the rights that they have as a shareholder are all listed in a statute already. So sole proprietorship, if you're the sole operator, sole proprietorship is probably the best idea for you. If you are going to be trying to do this with other people, maybe a corporation is better. It depends on the type of business you're doing. It depends on the future of what you plan on doing for raising money. There's really no easy answer, I'm afraid, because every business is going to be different. Every individual is going to be different. Retooling different can types for protection so consumers do not drink from the wrong item. Yeah, or maybe not selling laxatives in a liquid form at all. That's I tried to grab something silly, but you're absolutely right. Retooling different shapes. Maybe you could choose a shape that clearly communicates if you drink this thing, it's going to give you the runs. Maybe put a Mountain Dew sticker on it. Okay, well, that's.
Hey, Craig, since there's nobody else, let me get one in here. Sole proprietor, partnership, a married couple. Which is the right one for them if they both want to be owners of the business?
Corporation.
Yeah, for a married couple?
So,
okay.
For a married couple. Partnerships, the Partnership Act is maybe 7 pages, maybe 10. And in the Partnership Act, there's a lot of pages having to do with very specialized partnerships and trade names. So the Partnership Act being very small means your partnership has lots of flexibility, which can all go into your partnership agreement. The smallest partnership agreement I've ever put together is about 32 pages long. And that's the power of partnerships, by the way, is how much flexibility there is. The smallest corporation, on the other hand, can be done in 5 pages of paper, as we talk about when you go to the registry office. And that's because the Corporations Act is 76 pages long, and it builds into it all the structures, all the processes. How do you hold a meeting? That's in the Business Corporations Act. How do you hold a meeting? It's not in the Partnerships Act. I can guarantee you that. So when you're dealing with with married individuals, you can do a partnership. That's great, but you're going to have a very long agreement, and you're probably going to go short on it because it's your wife. I love you. What could ever go wrong? We'll be together forever. We don't need to spend money on a 32-page agreement to talk about what happens if one of us no longer wants to be in the partnership, because that's never going to happen. It's like our marriage and love ending. It's never going to happen. Well, marriages end. In which case, corporations are a much better way, because even if you don't have a shareholders agreement about what happens when we break up, you do have the Business Corporations Act that's going to provide you what the exit is going to look like when you're no longer married. So corporations are a much better idea that way.
Right, perfect. And with that, that's it. Thank you, Craig Sherburne, amazing lawyer at large, and of course one of our all-time favorite volunteers out of the Maji Center. We appreciate all you do for us and our students, Craig. Thank you so much. Again, folks, I want to reiterate, we're having a board game night next Monday from 4 till 6. So we'd love if you came and checked it out. We've also got some great sessions coming up. Trade show booth strategies is next Wednesday. The Wednesday after that, effective networking. The Wednesday after that, refining your pitch. And if you haven't already, book a spot in our business showcase and have an opportunity to show off and sell, or just show off some of the products that you've been developing throughout the program or throughout your time at NATE. Everyone is welcome, and everyone who signs up is going to get $250 to buy your marketing. And we're going to have 4 prizes of $2,000 each prize. So thank you, everybody, for coming out. Craig, amazing as always, and you can see the rave reviews in the comments there.
Thank you all for listening. It was a pleasure. Dale, thank you for putting it together.
All right, folks, have yourself a wonderful day. Take care, all.
Bye-bye.